What is your viewpoint when the tax is collected by the revenue during the investigation stage?
The endeavour of the Indian government, the GST Council and the board is very clear that appropriate procedures and method has to be followed while doing any collection, be it coercive collection, there are guidelines, be it arrest, there are guidelines, and for even summons, there are guidelines. So when any amount is collected during the investigation stage, it is imperative that the revenue follows these prescribed guidelines by the board.
How relevant is the appropriation of the amount collected during the investigation?
When the amount is collected during the investigation stage, generally in these cases, this amount is paid under protest. Protest means that whenever the matter on principles is decided in favor of the taxpayer, the amount comes back to him without any limitation being coming into play. As a result, it is important that the tax authorities issue an appropriate show cause notice to appropriate this amount collected during the investigation phase. The Bombay High Court in this landmark decision recently has upheld this position that the amount which is collected during the investigation but has not been appropriated by way of a show cause notice needs to be given back by way of a refund to the taxpayer.
What is the way forward?
The way forward is very simple. As far as the taxpayers are concerned, they must file the refund claim and get this money if this appropriation by way of issuance of show cause notice has not happened. As far as the revenue is concerned, they must ensure that appropriate show cause notices are issued in a time-bound manner. So both the revenue and the taxpayers have a duty to either file a refund or to issue these show cause notices. And depending on the time frame, the matter will be decided. The writ court remains the relevant jurisdiction for decision on these cases because these will be determined by right facts.